Folks will frequently ask us how much time they have and whether or not they should talk to the insurance company. Insurance companies will often provide a number of kinds of forms to them to sign. And essentially, here's what we tell them. That in Virginia, in most cases, and they certainly should consult counsel for their particular circumstance, but the statute of limitations for bodily injury in most cases in Virginia is 2 years. And that can be different for people that are in need of a guardian. It's different for children. There are exceptions to that, and they should consult counsel about it. But we are usually perfectly happy to have the client do whatever negotiating they want to do with respect to any property damage to their vehicle, to strike the best bargain they can with the insurance company about the value of their vehicle if it's been damaged or totaled. We're happy to counsel them about that a little bit and can sometimes be helpful with that. And they certainly can accept a check from the insurance company for the value of their vehicle if they're satisfied with the settlement, and sign over the title or accept it for the body shop, whichever, without the involvement of counsel, and it's not something to be particularly concerned about. On the other hand, insurance companies will often try and kind of sidle up to a injured person, particularly if they're very injured, and gain some trust and try and explain to them incorrectly, in my view, that they don't really need counsel and that the insurance company is going to look after their needs, and that they're just really wasting their money by talking to an attorney. And usually that kind of an approach will be soon followed by a request that the client or the claimant file a medical authorization or release, and the insurance company, under the guise of doing the claimant a favor, will go and collect up all of the accident-related medical records so that the case can be evaluated and they can pay the claimant back for those records. The problem with that is, and what's usually not stated, is that they can also use those authorizations and releases to go nosing around in the client's other medical records, and far too often where that's occurred, we've seen that the claimant next starts to hear about all the problems they previously had. You had a back injury before, et cetera, and the claimant said, yeah, but that back injury before was my lower back. This is my upper back. Well, they've just introduced an issue into the case that didn't need to be introduced. So we think that signing any documents or negotiating directly with the insurance company on any issues with respect to bodily injury should only be done after discussing all of the ramifications thoroughly with an attorney, and that usually can be accomplished at no cost. And then if it makes sense, go ahead. But most clients, it's their only case, and they're dealing with someone that is trained and experienced and does not have the client's best interests at heart. There's a conflict of interest there. Insurance companies make money by not paying out any more money than they have to, and while they won't say it, that's their true objective.